right, good afternoon, everyone. My name is Timothy Dance. I'm the marketing director for Ganic PC. I'm here with Mark Seib, who is the principal and managing attorney of the Midtown office. This is the Ask the Attorney series. Mark has started this series to try to provide as much value to anyone who comes on and watches. So please feel free to ask any questions that you may have throughout, and I'll make sure that he gets that question answered. There's some more people coming in. Awesome. Thank you all for attending. Mark, you can take it away.
All right. Well, thank you, Timothy. I appreciate that introduction. Again, everybody, good morning. Well, good afternoon as of 2 minutes ago. My name is Mark Seib. As Timothy said, I am one of the principals and managing attorneys at Ganic PC. I manage our Midtown, Buckhead, and Tucker offices. The firm, have expanded our office footprint a good bit over the last few years. We currently have 11 locations to serve you. We are up to 14 attorneys. We just had the pleasure of welcoming Steve Golden and Laura Suggs to the firm about not quite 3 weeks ago. So I encourage you, if you would like to place a closing with us, to go to our website. That's www.ganicpc, we're a professional corporation.com. There is an order title button there. You can submit a copy of the contract. We also have a little form that you fill out where you can pick whichever attorney that you want to close with and whichever location you want to close with. So again, I'm based out of the Midtown office, but I do travel for closings. We sometimes another office opens the file. Sometimes the attorney travels. We're sort of as flexible as you want us to be. We're really just here to try and make your life easy, the life of your clients easy. We sometimes close buyers in one location, sellers in another at different days, different times. Whatever it takes to get the deal across the finish line. We're here to serve you. That's really our role. So as Timothy mentioned, we started the Ask the Attorney series a few months back, and I would encourage everybody attending live to feel free to raise your hand. We can let you speak. We can also use the chat function if you have a question as we're going through the materials. I don't mind being interrupted. Timothy's going to monitor the chat function for me, and will let me know if any questions come up as we move along. We also are recording this session. We will post the recording on YouTube, and I was happy to see from our marketing team that we're getting some traction on YouTube as well. So obviously, middle of the day is tough for some people, but the content is available later if you want to access it that way. So all right, I'm going to go ahead and share my screen. So last month we did something called the Pop Quiz edition, and we had some multiple choice questions, and that was very well received. We got great feedback on that. So we decided to continue with that format for this month's session. And I'm going to share the screen so you can see the questions. And I would like, if you want to answer the question, feel free to do so either in the chat function or raise your hand, and we'll call on you and let you speak. So let's go ahead and do the screen share. Hopefully I'm picking the right one here. And all right, you should be seeing the multiple choice question. I'm going to move it to, by moving it to my other screen, that messed things up. So, all right, I'll leave it where it was. So Timothy, can you confirm you're seeing the first question in the multiple choice?
Yes, sir. We're seeing it.
Great. So pardon me, I'm gonna have to sort of bounce between my two screens, but the first question that we have is, who can sign a warranty deed on behalf of an estate? So our answers are A, the surviving spouse; B, an individual with power of attorney; the administrator or executor of the estate; or D, any of the above. So do we have anybody who wants to be brave and try and answer the question for the group? I'm not seeing any volunteers, so I'll go ahead and provide the answer. So the answer is C, administrator or executor, but I want to clarify the answer a little bit, because not all administrators would necessarily have the power to sign the deed on behalf of the estate. So with an administration, the administrator can be appointed either with or without powers. So if an administrator is appointed by the probate court with powers, then typically the powers include the power of sale, the power to sell at private or public sale. But that's only by virtue of those powers being granted by the probate court. So it all depends on how the petition for letters of administration was submitted. Some folks might think the surviving spouse could sign. Well, if there's a will, or if there's been an administration, the surviving spouse could be the person who is appointed with that power, but not necessarily. So you can't assume that. I mean, that could be a correct answer, but it's not always the correct answer. Under B, individual with the power of attorney, we get this question a lot. Powers of attorney, unfortunately, cease to be effective upon the death of the person who granted the power of attorney. So those are only good during the person's life. Now, they are still valid while that person may be, in a hospital, in a nursing home, incapacitated. That's really one of the points of having a power of attorney, is to, have a solution in those situations. But upon the grantor's death, the power of attorney is no longer effective. And now we're looking to the will, or to the probate court in an administration to give someone the power to sell the real property. Timothy, I see we've got something in the chat function. Was that a question for me?
No, that was to the attendee, sir.
Okay, all right. Just
let them know they can ask questions.
All right, so let's go on to question number 2. What document grants authority for the executor to sign on behalf of the estate? So choice A, petition to probate will. B, letters testamentary. C, letters of administration. Or D, affidavit of descent. Do we have any volunteers who want to try and answer that one? Timothy, are we seeing anybody volunteer raise their hand? I don't see any hands raised.
No, I don't see any hands raised.
Anybody in the chat function?
I think we should choose them.
All right, I'll give the answer. So the answer on this one is B, letters testamentary. So first you have to notice that we're using the word executor in the question. So again, you can have an executor who is appointed as part of a will being probated, or you can have an administrator being appointed as part of an administration. So you have really kind of 3 different ways, primarily, that the probate court can act. You can have a will, so you would petition to have the will admitted to probate, and ultimately, the will has typically names an executor. The person named isn't always the person who ends up being. We could have the executor is somebody who is already predeceased, the person whose will is now being probated. So obviously a dead person can't act as an executor, but you oftentimes will have somebody suggested as if the first executor cannot serve, a second or third choices are often provided. If there are no executors, then again, you can have someone come forth with the support of the other family members, the heirs, to be appointed as the administrator of the estate. So sometimes if none of the persons named in the will as an executor or a backup, if none of those persons are available, then we can have an administration with the will annexed. So we're still looking at the will, but someone who's not named in the will as a potential executor is appointed as the administrator, and they're usually appointed with powers. Or you can have an administration without powers, in which case we're still dealing with all the heirs. In fact, I have a file right now. We just got the title report back yesterday afternoon, and unfortunately, we have an administration with no powers, and we're going to have to track down 9 different heirs and get quitclaim deeds signed by all of them. So here again, the correct answer, since we asked the question, the executor to sign on behalf of the estate, that would be the letters testamentary. So just going through the steps again, if you have a will, then the first thing is a petition to probate the will is filed. Assuming the will is accepted for filing, then you have an order admitting the will to probate. And then the third step is letters testamentary get issued by the probate court. And that states that a person named in the will has been appointed as the executor of the estate. And we look to the will to make sure that the executor has powers. Typically, powers are granted in the body of the will. And if the executor has powers, power of private sale, power of public sale, then the executor ultimately will have the authority to sign on behalf of the estate. Letters of administration was kind of a trick and choice for you because letters of administration can sometimes give the administrator the power of sale. But again, you wouldn't have executor and administrator in the same question. And last is affidavit of descent. That is something that we closing attorneys will use as a solution where we don't have a will. And there's a question coming up later where we'll get into that a little bit in more detail. So for now, let's go ahead and move on to question number 3. All right, what document grants authority for an administrator to sign on behalf of an estate? So if you listen to my last answer, you should know the answer to this question, but let's go through them. So choice A, the petition to administer the estate, letters testamentary, letters of administration, or D, affidavit of descent. Any volunteers who want to try and answer this one? This one's basic. If you're listening to my answer on the last one, you should know. All right, Jaleisha, let's let you answer. So is Jaleisha allowed to speak? I'm going to ask you to unmute. So Jaleisha, what's your answer?
Is it B, letters testamentary?
Actually, no, it's letters of administration. So thank you for answering. I appreciate the participation. So again, we're trying to distinguish between a will, which will lead to letters testamentary, or an administration, which we do when there is no will, or a will, but again, none of the executors named are able to serve. So then we would have letters of administration. So this was a little tricky in that we had choices B and C, and we also have got that affidavit of descent. So we'll get into that again in a later question. So the letters of administration, we're also going to be looking to make sure that the powers are granted by the probate court. And so the letters of administration, the form that's most often in use by the counties, there's a place for the probate judge to initial whether or not the administrator has been appointed with powers or without. And that's really crucial, because if the administrator has powers, then we have a fairly easy solution to getting our closing across the finish line. If the administrator does not have powers, then we're dealing with that situation I just described, where we're having to track down in this file. I just got the title report back, 9 different heirs. And unfortunately, this administration was attempted back in, I think it was 2002. So we're 21 years later with these 9 persons named in the petition for letters of administration. We don't know if those people can be found, if they're alive, if they're in prison, if they are missing, MIA. So we're going to have a really tough time trying to figure out how to get all of the various heirs tracked down. And if, for example, if somebody's now deceased, we're then looking to their heirs to figure out who stands in their shoes at this point. So it's going to be rather complicated to clear title to that. So, in general, of course, we always recommend that people who own real property have wills wherever possible. And if they don't have a will, then certainly, if they own the property, with their spouse, that they own title in a certain format. We've got a question about that coming up. So let's go ahead and move on to number 4. Timothy, just confirm you're seeing question number 4 at the top of the screen now.
Yes, sir.
Okay, great. All right, so number 4 was what I was sort of about to preview and decided, hold on, let me get the question out first. So number 4, if a co-owner of property passes away, which type of ownership structure avoids probate and administration? So A is ownership as joint tenants, or B, ownership as tenants in common. All right, so I know you guys know the answer to this one. Any volunteers? Somebody else want to be brave? All right, no brave audience members. All right, Jaleisha, we'll let you go again.
I must redeem myself. Is it joint tenants?
Joint tenants, that's correct. So thank you for volunteering again. Yay. Good
Thank
job.
you.
So GANIC, as a firm policy, if we have 2 buyers, we always default to joint tenants, and the full phrasing on that is, and we type it into the warranty deed or the limited warranty deed. So joint tenants with the right of survivorship, comma, and not as tenants in common. So we want anybody looking at that deed to know very clearly of what the intention was at the time that the buyers took title. Unfortunately, when I go back in history and, we uncover deeds, people have owned property for, 20, 30 years. I don't know why, but back in the day, it seemed like a lot of attorneys didn't either ask the question or have the policy that GANIC has, which is defaulting to multiple buyers, more than 2 or more buyers, always taking title by default as joint tenants. And by doing that, we save future title examiners and closing attorneys a lot of work, because if I have a closing and we run title comes back and it's tenants in common, and if you just put in names of 2 people and you don't say anything about how they hold title or take title, then the presumption in Georgia is that they take title as tenants in common. And what that means is they each own, let's say we have 2 people, they each own a 1/2 interest in the property, and that 1/2 interest passes according to their will. If they don't have a will, then it passes according to something in Georgia called the law of intestacy. So intestacy means you died without a will. And the law of intestacy in Georgia creates certain categories of what we call the heirs at law. The first category is spouse and children, and they take title as a group. So if we have a surviving spouse and we have surviving children, they all, let's say there's a surviving spouse and there's 2 surviving children. So we have 3 people who are now the owners of that property. A third, it's a little more complicated than that. If the spouse is on title, then the spouse who passed away has a 1/2 interest, and that 1/2 interest is now split amongst the 3 heirs at law. The spouse, who already owns a 1/2 interest and now owns another 1/6 interest. And then the 2 children, who each also get a 1/6 interest, because let's say it's the husband who passed, he owned half, and now his 3 heirs at law take his half and they split it up. So it's fine if the children are all adults, but if they're minors, well, guess what? Now we're going to have to go to the probate court and ask the probate court for a guardian to be appointed to represent the interests of those children in the real property. So it just got a lot more complicated. If instead that husband and wife had taken title as joint tenants with the right of survivorship and not as tenants in common, then in my scenario, the wife would now be the sole owner of the property and would be able to mortgage it, sell it to pay off the debts of the estate, sell it to, provide for the children, But without that language, we're kind of stuck. So it's real important. If I do a closing, and at the close, we have some forms that we send out ahead of closing, buyer information form, seller information form. And if the buyers answer all of our questions, we will know that in this particular case, the buyers don't want to be joint tenants. Sometimes people don't answer that question. So it's up to us to, during the pre-closing process, to try and figure out the answer, or at the very least at the closing table. And I've had this happen where, I am at the closing table and I'm just making small talk, and I realize, okay, my buyers are actually two friends who are going to be roommates, and they both wanted to have the investment for tax reasons and appreciation of property. And they don't want to be joint tenants. So what's real great about, even if our seller has signed, like as part of a mail away, or they signed a day, sometime before the buyer signs, we're able to go into our software and swap out the first page of the limited warranty deed and let those buyers take title as tenants in common instead. But that's a conversation that we want to have ideally ahead of time. And again, it's really up to the closing attorney is the last set of eyes and ears to try and catch that and make sure we do it right. But I think our buyers are really benefited by our default to joint tenancy, because 9 times, or maybe 95 times out of 100, that's what our 2 or multiple buyers would like us to do. All right, next question. Who cannot serve as an executor? A, 17-year-old cousin of the deceased. B, child of the deceased who does not live in Georgia. C, an ex-spouse of the deceased. Or D, a next-door neighbor of the deceased. Any volunteers? Anyone? Bueller? Timothy? Anyone? Jaleisha, you want to go again? All right, we have another volunteer. Thank you, Jaleisha. Number 3. So which of the 4 answers would you like to select?
I'm sorry, number 3 or number 5?
I meant this is your 3rd time answering a question, so thank you for that. So we're on question number 5. Sorry to confuse you.
It's okay. No problem. Is it the next door neighbor?
That cannot serve. It's actually A, the 17-year-old cousin of the deceased. And the reason why is because a 17-year-old in Georgia is a minor, and they do not have the authority, they're not yet an adult, to serve in the capacity as an executor. So it's a little bit tricky, because most minors would not be named as an executor in a will. But all of those others, I thought the answer that people were most likely going to select is C, an ex-spouse of the deceased. It would be an unusual scenario. Most times people don't want their ex-spouse to be their executor, but sometimes people write their wills, then they get divorced, and then they forget they need to update their will. And so they could have named their then spouse, who is now their ex-spouse, and some ex-spouses actually are willing to serve. I mean, not all divorces end in the people hating one another going forward. So that definitely can happen. The next door neighbor could easily be, I mean, we don't see that a lot, but as long as that next door neighbor is an adult, they can serve. All right. So Jaleisha, thank you again for answering. Number 6, if an estate is the seller and wants a wire for their proceeds, what bank account can the wire be sent to? A, the estate's account. B, the account of one or more of the heirs. The executor's personal account. Or D, the listing agent's account. Anyone want to try and answer that one?
Julicia's on the roll, sir. She's got her hand up again.
Anyone else want to be brave?
There we go.
All right, Stephanie, yay, thank you.
Is it A?
That is correct, the estate account. So a lot of times we get to closing. Thank you, Stephanie, for answering. A lot of times, well, we try not to, organic, we try not to let this get all the way to the closing table without getting it resolved. We in our request for seller information form, we ask a question. Does the seller want a check for their proceeds or a wire? And if they want a wire, we ask them for their wiring instructions. And part of that is the name that appears on the account. And if I see an executor, let's say the executor is John Smith, and the executor answers that question about wiring instructions, name on the account, John Smith, that raises a red flag for us, because we want to see John Smith, comma, as the executor of the estate of Matthew Smith. Or maybe a better answer, the estate of Matthew Smith. Then we know the money is going to the right place. But if we don't see some reference to the estate, then we know potentially that we have a problem. And so the way our sellers answer that question is a trigger for our closing coordinators to follow up with a follow-up question asking for more information about that. At Gannett, we use a system called Smart Close, and we have built that out to a sort of an extreme level, so that things that used to trip us up at the closing table, we really don't want that to happen. Our goal at Gannett is we want closings to be happy people walking in, happy people walking out, and we want you in and out in about an hour wherever possible. So if we have snags at the closing table, like the executor who, when I'm sitting there saying, well, the money can't go to you individually because there are other heirs, and we need to make sure that the heirs also get paid out of the estate. So we can't give you individually the money. We have to give that money to the estate account. You as the executor, what you do after that, that's kind of up to you. But Gannett needs to make sure that we're following the letter of the law, and we know where the money needs to go. We're ensuring title. We have rules that the underwriters, have for us to follow. And so a lot of times executors, if they're, they'll say, well, I'm the sole heir. Well, how do I know that? I mean, I can look at the letters to probate, requesting to probate the will, the petition to probate the will. And the answer sometimes can be found there. But oftentimes we do have other heirs. We need to make sure that those heirs are going to get their share of the estate. So if we ask the question ahead of time, then we can tell the executor, look, you may have probated the will, but you're maybe doing that by yourself. You don't have an attorney advising you. You're also going to need two more things. You need to request a tax ID number for the estate, because we have to report the sale to the state of Georgia potentially, and also to the IRS. We cannot report a sale under the deceased person's social security number. So sometimes the executor will give us their individual social security number. That's really not correct either. We will report it that way if we're kind of stuck without any other option. But what we would much prefer, we really push to make the executor do this, is to apply for a tax ID number for the estate ahead of closing, and to also set up the bank account in the name of the estate. So having those conversations ahead of time really can save us a lot of trouble at the closing table. And of course, the D was meant to be a little bit funny. We certainly cannot put the proceeds of the estate in the listing agent's account. All right, number 7. This is a long one. So the title examination shows that your client is not the actual owner of the property to be sold. Instead, your client is the child of the former owner who died 4 years ago without a will. Unfortunately, the estate was never administered. How can we proceed to closing? So I think I've kind of already given this answer earlier in the presentation, but let's see how you guys do. So here are your 4 choices. Let me see if I can minimize that just a little. All right, I think, yeah, there's all 4 of our answers on one page. So A, tell your client you will be unable to list the property for sale. B, find a buyer and hope the closing attorney doesn't pick up on the different names. C, request a copy of the death certificate, compile a list of all the possible heirs, and then identify someone who can execute an affidavit of descent. And finally, D, the closing must be delayed to administer the estate. An administrator must be appointed and given authority by the probate court to sign on behalf of the estate. So this one's a tough one, I think. So any brave volunteers want to try? Brandy Burkhart, who's with Gannick, you want to try and give us the right answer? No, I guess not. All right. So the correct answer here is letter C. So we've talked about, we gave this as a potential answer in some of our earlier questions. An affidavit of descent is a document that the closing attorney will create. And what it does is it will list out all of those persons who are considered the heirs at law for the deceased party, the deceased former property owner. So it's a way that we can avoid going to the probate court, having to petition, having to wait for an order to be entered, having to wait for an administrator to be appointed, having to get an administrator appointed with powers. But we have to wait a certain time period before we can, choose this as our option. So an affidavit of descent, we would ask, somebody who knew the person who passed away, all right, well, when Johnny died, was Johnny married? All right, well, was his spouse was still living at the time of Johnny's death? Yes. Okay, great. And so what was her name? All right, we'll write that name down. Were there any kids? Because remember, in the first group of heirs at law, the spouse and children are considered one class. So we're first going to ask, was there a spouse? Were there children? If there were both, we need to list all of those. If there was a spouse who had already passed away, but there were still living children, then we're going to want to know who the children are. If there were, depends on who died first. If the spouse died first, then we're not going to worry about the spouse. We're just going to worry about the children. But let's say Johnny died, and at the time he died, his wife was living and the 2 children were living. Then at the time we're trying to close, by that point, now his wife has passed away. So we're going to look to who are the heirs at law of the wife, or we're going to look to, did the wife have a will? Was that will probated? So it can get very complicated if we don't have a will, and if an administration wasn't handled at the time that the, kind of contemporaneous with the time that the person who owned the property passed away. So kind of the affidavit of descent is really our solution of last resort, but it does sometimes get used. So we have to request a copy of the death certificate to confirm that the property owner has passed. We have to compile the list of all possible heirs and then identify somebody who can execute the affidavit of descent. So what we can't do on the affidavit of descent is allow one of those persons who stands to inherit or profit from the sale of the property to be the person who provides the list of the heirs, because it's self-serving. I'm going to say that I'm the sole heir. I'm the surviving spouse and there were no kids. Well, what if, when the husband died, maybe he was married once before and had 2 children from his first marriage. And then he married a second wife, and the second wife was living at the property, but she wasn't on title. And, she now wants to be the one who, essentially inherits the property. Well, those kids from the previous marriage also, in my scenario here, are heirs at law. So they have a right to 1/3 of the proceeds, and, under that set of facts. So we have to make sure that, that's one of the title claims that all closing attorneys are really worried about. Like, if we don't make sure that we handle an estate, and a year later that heir whose rights weren't handled properly comes forth, we've got a title claim. And believe me, no closing attorney ever wants to have a title claim. What a lot of real estate agents may not realize is that when a title claim is made, the first person who gets contacted by the title insurance underwriter is the closing attorney, and we have liability for the policies that we issue. Now, ultimately, if the closing attorney can't fix the problem, if there's a loss and the closing attorney can't pay it, the title insurance company underwriter, that's the reason you have insurance, to make sure that if the closing attorney doesn't make things right, then the title insurance company will. But we're going to be the first one asked to solve that problem. I can tell you another example, not estate related, but if we, miss taxes and our sellers moved out of state, well, guess who's going to write the check? The closing attorney. So, at Ganic, we have a lot of systems where we have multiple eyes looking at every file that we close. We have a system, checks and balances, so that things don't slip through the cracks. Not every closing firm, I think, is as careful or as sophisticated as we are. Ganic was founded in 1978. We've been around for a while. We're celebrating our 45th year in operation, and over that time period, we've had the opportunity to develop a lot of systems to make sure that we do excellent work and things don't slip through the cracks. So, all right, moving on to question number 8. And then we have a couple questions that were submitted ahead of time that I'm going to answer. And again, for my participants today, if you have any questions you'd like to submit, probate related or otherwise, I'll be happy to answer those. So we've got about, let's see, not quite, a little over 20 minutes left. So this plus 2 more questions that we had in advance, and then I can take questions from the audience. All right, so number 8. If a will contains a specific bequest of property to a certain person who is named in the will, which of the following can happen? Choice A, the executor can transfer title to that person as instructed by the will. B, the executor can sell the property to a third party in a private sale. C, the executor can sell the property to another one of the heirs. Or D, all of the above. Any volunteers? Timothy, or seeing anybody? No volunteers for this one. This one's maybe a little tricky too. So the answer is actually D, all of the above. But I've got to clarify, because we can have some different sets of facts that could maybe make one of these answers incorrect. So A, the executor can transfer title to that person as instructed by the will. This does happen as long as the assets of the estate are sufficient to pay all of the bills. So let's say the person died and they had a bank account or a stock portfolio that was worth, let's say $150,000. And then we have the debts of the estate that we have to pay. So they've got a credit card with a $10,000 balance, and they've got, maybe, let's say they own the home free and clear because they were elderly. They have the expenses of their last illness. They have the hospital bills. They have the bills for the burial service, cremation, all of those things. If there's enough liquid assets of the estate to pay all of the bills, then the specific bequest of the property, let's say, I hereby leave 123 Main Street to my brother Paul. As long as there's other assets of the estate to pay the debts of the estate, then that specific bequest can happen. So choice B, the executor can sell the property to a third party in a private sale. So let's say the person who died didn't have that bank account, didn't have the stock portfolio, and left, $150,000 worth of debt that needs to get paid. And the only asset of the estate is that property that the seller owned free and clear. Well, now the executor cannot honor the specific bequest because we have to pay the debts of the estate. So now the executor could sell, assuming the will normally does provide the executor with powers to sell the property in either a public or a private sale. Most executors sell in a private sale. They list the property with a real estate agent. The real estate agent gets offers or multiple offers. We end up with the winning offer, and we close in a private sale. That's what we've seen most often. Could the executor sell the property to another one of the heirs? Well, yes, the executor has a duty to make sure that they're selling the property for the highest price possible, because again, they want to represent all of the heirs of the estate. They want to maximize the amount of money that the heirs can receive as part of their being an heir. So as long as another one of the heirs is willing to pay a market price, then that can happen as well. So, again, D, all three of the choices above can happen under certain set of facts. Okay. All right. This is not on your screen, so I'm going to stop my screen share. All right. And then just back to us. We had a couple questions that were submitted ahead of time. So the first one, and it just so happens that they are probate law related. So this was our pop quiz probate law edition. So the first question, I'm going to leave the person who sent it nameless for now, but I will follow up with an email to both of these persons after today's presentation. So the first question is, what recommendation would you have for a buyer that wants to purchase land where the land next to it is landlocked? And then they put in quotes, they need access to the lot to get to the land they are purchasing. There is no easement agreement, and they cannot locate the owner's heirs. The owner is deceased. So this one I can't really fully answer without asking some follow-up questions. But let me say, here's what I'm concerned about. Well, one is you've got two lots next to one another. One is landlocked, one is not. So the one that is landlocked would need to be granted an easement over the property that is not landlocked. And it may be that the purchasers are wanting to purchase the lot that is landlocked. And obviously they don't want to purchase it without having access from a road. So part of the purchase agreement would be written such that we'll buy from you, you're maybe the owner of both of these lots, but as part of our purchase of this landlocked parcel, we also want you, the seller, to grant us an easement across the lot that does have access. So that's how we would solve that problem. Now, the rest of the question was, they need access. I think I've answered that. They cannot locate the owner's heirs. The owner is deceased. Well, that's what we were just talking about. If we can't track down the owner, then, we're going to have to come up with one of our other solutions. Is there a neighbor who knew the person who passed? Can we get an affidavit of descent? Is there somebody who's an heir who can come forward and petition a probate court to be appointed as the administrator of the estate? So there's ways that we could maybe solve that problem, but it's sure going to be difficult if we cannot locate the heirs. we may want to consult with an attorney who specializes in probate law for that one. Again, keep in mind, we are at Gannett, we're closing attorneys, real estate lawyers. We know enough about probate, maybe to be dangerous, but I don't purport to be a probate attorney. So we would probably want to engage, unless we can track down somebody who can have some knowledge about the person who passed away, or maybe, you know, we can try and get a death certificate from the state of Georgia. That is a public record, so we can send a request to I think it's the Office of Vital Statistics for that. But it's going to be a lot of work and take a while to get that one solved. All right, so my next question is, I have a divorced, and then it's followed by 4 question marks. So it sounds like 2 parties were divorced for a number of years. Looks like they divorced in 2002. The spouse who then, the ex-spouse who passed away, had no will, 2 living children with a general warranty deed, no survivorship rights, no probate, and the divorce decree stated to sell the house. The living spouse is in contempt. However, will the living spouse be responsible for any of the deceased's IRS debt? And does he owe any proceeds to the children? All real estate taxes and mortgages have been paid by the living spouse. So this one's chock full of issues and questions that, again, it's hard. I have follow-up questions which I have to ask in order to try and really get to the bottom of this. So if I'm understanding, we have originally, well, I don't know if there was 1 or 2 owners on the deed originally. That's not probably my first question. We could have a scenario where we had, let's say it was the husband who was in title. He and his wife then got divorced. In the divorce decree, it was agreed that the husband would sell the property, and part of the proceeds would go to the ex-spouse. We're going to need to follow the terms of the divorce decree. So we really need to run title, look at the divorce decree, look at how they held title, the timing of everything. You know, once you divorce, your ex-spouse is no longer considered an heir at law. So the question does say that there was no will. So if we have an owner who dies without a will, they're the sole person in title, and they have 2 living children. Well, if they're divorced and not remarried, and they have 2 children, then the children are the ones who inherit that property at this point. And it may be an unfortunate scenario where we're going to have sort of like probate court and divorce court sort of duking it out. So we really need to delve more into that one and get some more information. Like, again, running title would be the first step, and get all the dates down, and then figure out, like, you know, what happened first, and that will tell us what controls. All right, so we've got 10 minutes left, and I am open to any questions, probate related or not. So I see we have a hand up. Senia, if you want to unmute.
Hey, Mark.
Hi.
I have a question.
Good to hear your voice.
Yes, thank you. So in regards, it's not in regards to the probate court, it's a different topic. So who is ultimately responsible to file a 1099-S after closing?
Actually, it's the law firm's obligation. So at Gannett, we get the seller or sellers to execute the 1099. And our policy is I don't let sellers walk out the door without a hard copy of that document. I know some law firms will state that their settlement statement is a substitute 1099. But again, it's the law firm's responsibility to report the sale to the IRS. And we have that job at the beginning of every year. At Gannett, we have a accounting department of, I have a CFO. The CFO has an assistant. And that assistant, her name is Tracy. Tracy's job every year is to get those reported to the IRS. I think don't quote me on this, but I think we have to do it within 30 days, or maybe it's 60 days. Tracy would know the answer to that question. So we really work hard throughout the year with our closing staff to try and capture the correct information at the closing table so that Tracy doesn't have trouble reporting later in the year. And so we have our answer from Brandy Burkhart, who is also one of our longtime paralegals. I think Brandy's been with us over 20 years, as I recall. Brandy said the deadline is March 1st. I believe I saw that pop up. So thank you, Brandy. Do we have another question? It looks like we do. If you want to unmute yourself and we can hear your question.
Hello, and thank you. Appreciate the session and your time.
Yeah, good afternoon.
Try to make thank you. Try to make this quick. I was in the middle of a renovation and fell behind, and I'm now trying to find out if the house actually went to foreclosure. I scrambled around to find a buyer who was going to take it off my hands as is, but according to the attorney for the note holder, it was foreclosing on the 7th of March. But then the lender turned around and called and asked me for an inspection for the 13th of March. So I don't know how to confirm if it foreclosed or not. And if it hasn't, I wanted to proceed with my buyer. The other part of that is I called where you run the legal ads, and they said the house was never listed in the public, I guess the public forum through the paper or whatever. They don't have my address of ever being listed and run for 4 weeks.
So for a foreclosure, so sounds like there was a note, a lender, and there was a default in terms of payments. And, most notes say, once you're 30 days late, then the lender can send you notice of default and accelerate the debt. And once they do all that, so they are obligated to let you know that there's been a fault. Typically, there is an opportunity to cure the default. If no cure takes place, then the lender is obligated to advertise the foreclosure in each county. Has something called, it's a weird title, it's called the legal organ. It's the publication where legal notices are published. So for Fulton County, for example, that's the Fulton County Daily Report.
I talked to them, they said it never ran.
And so if we can, look, if you said it supposedly was sold on March 7th, so just not quite a week ago. So then that ad would have had to have run for the 4 weeks in a row of all 4 weeks of February. And if that didn't occur, then a foreclosure could not have taken place without the proper advertising. So you may be in luck, and I would certainly be in communication with that lender and find out from the lender who was representing them for what law firm represented them as part of the foreclosure. If maybe they have in-house counsel, but most times they use outside counsel. Get in touch with that law firm as well, and ask for, I'd like to get a copy of the foreclosure deed. It would be too recently created for us to be able to run a title search and find it. Most counties, if a deed is filed, it takes several weeks for us to be able to view it in the public records. So you're really going to have to deal with that lender and their counsel in order to try and get to the bottom. And they may be happy to find out that you have a buyer, because then they can get paid in full. Most lenders really don't want to foreclose because often when they go to sell it on the, once they foreclose, then they maybe have to finish making repairs, get it ready for market, pay a commission. So oftentimes they don't recover the full amount of their debt. So it may be a better scenario for them to allow you to sell it at this point. So I certainly wish you the best of luck with that.
Thank you. That was
All
great
right.
information. Thank you.
Terrific. Any other attendees? Any other questions? We're 4 minutes to go. Anybody else? All right. Well, I want to thank everybody for being here. Again, if you'd like to place a closing with Gannett, you can go to our website, www.gannickpc, P as in Paul, C as in cat, .com. Gannett is a professional corporation. That's why we have the PC in there. You can also call me or email me if you have questions. The office phone number here is 404-892-7300. And my email address is Mark S, M-A-R-K-S for my last name, at gannickpc.com. So again, appreciate y'all turning out. This will again be posted on our YouTube channel. So really appreciate everybody's attendance. Timothy and Brandy, thank you both for being co-hosts. I really appreciate your assistance with this. All right, everybody have a great afternoon.